All persons having business before the Honorable Associate Judges, now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and this Honorable Court. This Honorable Court is now in session. Please come to order.
Good morning, everyone, and welcome to the District of Columbia Court of Appeals. Before we start with this morning's calendar, I'd like to say just a few words about the manner in which we are proceeding. As you all are well aware, the COVID-19 pandemic has affected life in all sorts of ways, and it has definitely affected how courts do their business. The District of Columbia Court of Appeals is continuing to work very hard, and we're issuing opinions, but we've had to modify the way in which we conduct oral arguments out of concern for your health and the health of our staff people. So we're proceeding today by way of virtual oral arguments. We've done this a few times before, and we're glad we have this alternative to having no arguments at all. And fortunately, the public will be able to watch these proceedings as well. We have a channel on YouTube that allows the public to watch in real time, and you can access that through our Court of Appeals website, which will give you the information about how to access that. So we're trying to continue providing access to justice as well as public access to our proceedings as well. Our court staff has worked very hard to try to make this technology work smoothly. And I know they've worked with you and they've worked with us. Inevitably, some glitches will arise. So if those things do happen, we ask that you be patient with us and we'll get through this together. So with those preliminary remarks, I will call the first case of Carrington Williams versus United States, 17 CF 944.
May it please the court, Fleming Terrell on behalf of appellant Carrington Williams. I'd like to reserve 2 minutes of my time for rebuttal. We've raised two issues on appeal. I want to be sure to get to both of them, but I'd like to start with the cross-examination issue because that affects every conviction here. The trial court erred in preventing the defense from cross-examining Mr. Brown about the previous night's assault on his newborn's mother during a dispute that Mr. Brown himself repeatedly identified as the reason for his heavy drinking and the driving force behind his state of mind and thus his behavior at the time of the charged incident at Ms. Belton's apartment. Now that evidence was admissible on multiple grounds, including to show bias as it provided a distinct motive to shift blame. But before I talk about bias, first and foremost, the defense was entitled to probe this dispute at the hospital because the prosecution and Mr. Brown affirmatively put it in issue as inextricably intertwined with Mr. Brown's behavior when he encountered Mr. Williams the following night. The defense—
Ms. Terrell, I'd like to ask you a hypothetical question. Let's assume Mr. Brown had not testified and that we weren't talking about his testimonial bias, we weren't talking about his credibility. Would you still have argued that you should be able to put on this evidence of what happened at the hospital room because it bore on his propensity to assault when he was angry and would have helped point the finger away from your client?
We probably would have sought to do that. There is a propensity inference, which I think is legitimate here where we're talking about a witness, not a defendant. But here the evidence was admissible for on many other bases aside from propensity. This court really doesn't need to grapple with that question of whether this would have been admissible solely for a propensity showing. It was more like Tolliver evidence, the way it came in, because as a result of the prosecution inquiring about this on direct examination and Mr. Brown saying the reason he was drinking so heavily, the reason he was drunk his state of mind at the time of the charged offense stemmed from this incident that he'd had with his newborn's mother at the hospital the night before. So it was the beginning of the story. It was inextricably intertwined with the account of what happened during the charged event. And that's why I say, if this had been a defendant, it would have been something the government sought to introduce as Tolliver evidence rather than for a propensity inference. The defense had opened on this theory that it was Mr. Brown who was drinking heavily and who flew into a jealous rage when his girlfriend's ex unexpectedly arrived at the door in the middle of the night and who assaulted both his girlfriend and Mr. Williams. And the prosecution elicited this evidence about the drinking and the reason for it to foreclose that theory on direct. It elicited that Mr. Brown had begun drinking early that morning and asked why. And Mr. Brown's answer was, because of what happened at the hospital the night before. He said, I just had a child the night before and I wasn't able to see my child. I was a little depressed, really. The prosecutor followed up and asked, why were you upset? And Mr. Brown said, misleadingly at best, the mother wouldn't allow me to see the birth. And it was going to be a long time before I would be able to see my child. Now, those questions.
There was a lot of evidence that he was an angry drunk. What did these details of the hospital add to that?
This was critical to that evidence because, of course, the defense theory was built on that evidence, that Mr. Brown was present, Mr. Brown was drunk, and when he gets drunk, he gets angry and violent. It was essential for the government to undermine and inoculate Mr. Brown against that theory. And the way they went about doing it was to point to this incident at the hospital the night before and elicit his testimony that he was depressed. And then on cross-examination, Mr. Brown volunteered 5 more times that he was depressed as a result of what had happened the night before. So he was drunk.
Mr. Terrell,
Yes.
Mr. Terrell, I'm sorry. So I thought, as did Judge Fisher, that you're concerned that, and I was taken by the government's argument in this respect, he was a drunk who gets violent when he's drunk. That seems to support your argument that Mr. Brown, in fact, was the aggressor in this case. He was drunk, he was angry, it was the middle of the night, and therefore he acted in the way that was consistent with your theory of him being the perpetrator of this offense. What does the rest of that have to do with it? Why isn't that sufficient to support your theory, at least as Tolliver evidence of your client's innocence and Mr. Brown's guilt?
Well, for this incident, it was essential because that was very powerful evidence in support of the defense theory. So it was essential for the government to be able to point to something to say, yes, he was drunk this time, but this time he wasn't drunk and angry. He wasn't drunk and violent. And Mr. Brown himself drew this critical distinction between being depressed and angry when defense counsel directly confronted him and said, wasn't it you who was drunk and who flew into a rage and picked up the knife and started waving it around? And Mr. Brown's response was, that didn't happen. And he said, you asked me earlier, I said I was depressed. Depressed and anger are 2 different things. I said I was depressed because I was not able to see my child since that child was born. I was never angry. So by Mr. Brown's own account, the purported fact that he was depressed and what he was depressed about precluded him reacting in an angry and violent way that the defense had proposed. And so the defense was entitled, it's black letter 6th Amendment law, that the defense was entitled to probe that explanation and to present evidence that contradicted the account, because what happened the night before at the hospital showed that Mr. Brown wasn't depressed. The dispute with the child's mother, not only had he misrepresented whether or not he'd seen the child and omitted materially his role in being barred from seeing the child further, but what happened that night showed that he wasn't just depressed about not seeing his child, he was angry. He was so angry that it drove him to physically assault an intimate partner. That directly contradicted his testimony at trial that the following night, when by his own account, he still is caught up in what has happened the night before. That's what's driving his behavior and driving his state of mind. His claim that he was just depressed and too passive to engage in an assault against Ms. Belton and Mr. Williams was directly contradicted by the night before.
let's talk about standard of review. One cannot read this record without having a very bad impression of Mr. Brown's character. And so what was the impact of excluding these details when all this dirt was laid before the jury that made it clear he was not Prince Charming?
The impact was critical because this went, as I said, to the very heart of the defense theory of the case, that it was Mr. Brown who lashed out in a drunken rage. The prosecution had its opportunity to try to challenge that theory with this explanation that no, he wasn't. He was just depressed. And Mr. Brown hammered that notion 5 times on cross-examination after having brought it up on direct. And that was something that none of the other evidence about what happened thereafter between Mr. Brown and Ms. Belton rebutted. This would have shown not only that he was simply not credible, he was sort of caught telling the jury under oath information that was at best materially misleading about that incident that he was saying was critically intertwined in what had happened during the charged incident.
I'd like to save some time to talk about burglary, but let me ask if my colleagues have questions about this topic before we shift.
I do have a question. So let's assume that the cross-examination of Mr. Brown was improperly limited. And let's even assume that the standard of review is the Chapman standard here. Part of the evidence was that a relative of Ms. Belton's was in the apartment and witnessed a portion of the assault. What can you say about whether or not the limitation on cross-examination ultimately was harmful, given that direct evidence that the assaulter in this case was your client and not Mr. Brown?
I'm not sure I follow about the relative in the apartment. I know that there was testimony.
An aunt, was there not?
Yes, although the aunt did not testify. There was no one other than Mr. Brown and Ms. Belton, who, according to the defense theory, and that was fairly well supported by the evidence, was sort of under Mr. Brown's thumb. They're the only two who testified that it was Mr. Williams who committed this assault. And I should say—
Did the aunt not come into the bedroom at one point in time? Remind me of what the evidence was, please.
Ms. Belton testified that the aunt came into the bedroom and sort of pulled Mr. Williams away from her. But that was simply Ms. Belton's testimony, which, as we've sort of laid out in our brief, was subject to all kinds of credibility questions. I don't think it undermines the impact that this evidence about Mr. Brown's credibility and about his state of mind at the time of the assault would have had. And to be clear, the jury already discredited significant parts of Ms. Belton's and Mr. Brown's account. They acquitted on AWIC of Brown, and they hung on the threats charge. That means they didn't believe the testimony from Ms. Belton and Mr. Brown that Mr. Williams had threatened to kill Mr. Brown during the fight. They also failed to reach a verdict on assault with a dangerous weapon of both Mr. Brown and Ms. Belton. So that means at least some of them, didn't believe the testimony that Mr. Williams wielded a knife. So if those jurors had known that, in addition, Mr. Brown's protestations that he was just too depressed over this dispute with his child's mother to be angry or violent actually hid the fact that he reacted with just such anger and violence by assaulting the mother of his child, and that as a result of that domestic violence assault and a string of others before it, Mr. Brown had an exceptionally powerful incentive to tell police that someone else this time, Mr. Williams, and to stick with that story through trial and to make sure that Ms. Belton stuck with that story through trial. Those juries could very well have doubted more of his and Ms. Belton's story than they already did, including who was to blame for being the aggressor. So I think under Indy's standard, the rulings that kept that information from the jury can't be held harmless. We do think the Chapman standard applies here. These are clearly Sixth Amendment violations, both on the bias point and on the straightforward cross-examination point. And so the exclusion certainly can't be found erroneous beyond a reasonable doubt. With that, I see my time is drawing short. Perhaps I should move to burglary unless there are additional questions.
Please.
So the burglary issue is really a straightforward statutory interpretation claim. The trial court erred.
I wonder if what your argument is. Maybe I've misread your brief, but I thought you conceded that in a situation where someone had been admitted to the apartment lawfully and thus had not committed burglary by entering, if that person entered a bedroom where they were not welcome, that would be a burglary.
No, we haven't conceded that that's the law in this jurisdiction. That is a common law doctrine, which has been adopted by courts in a number of other jurisdictions. It was common law in DC in that Bowen case that the government cited. And what we said is, yes, that doctrine exists, but it doesn't inform the question of whether when the legislature added the term room used as a sleeping apartment to a statute intended to protect dwellings and only dwellings against burglary with heightened protection.
So in that hypothetical,
yes,
a workman's admitted to the kitchen to fix the dishwasher.
Yes.
And he wanders upstairs, and let's assume the bedroom door is locked and he goes in there. Is that to commit a crime? Is that a burglary or not?
That is a question that this court hasn't addressed. It certainly would not be a burglary of a room used as a sleeping apartment, because that term, it's clear from the plain text of the term, the use of the word apartment, which connotes a separate dwelling unit, from the legislative history, from the common law that it was trying to clarify in the statute, that a bedroom within a single family home, an ordinary bedroom, is not a room used as a sleeping apartment. Now, under this doctrine that the government has relied upon, some courts would say that that entry was a burglary of the dwelling as a whole. That's what Bowen said, right? The defendant was authorized to be within the home, but not to go into the locked bedroom at night while someone was sleeping in there. And so it was the entry into that bedroom that constituted what was at the time required as a breaking. And there's sort of this legal fiction that it was a breaking of the dwelling as a whole. That whole doctrine is a non sequitur here, because it's designed to make sure that someone doesn't get away scot-free with doing what you described the workman doing, being invited into the home and then going into the part of the home to which they were not authorized without a burglary charge just because they had permission to be somewhere else in the home. Here, Mr. Williams did not get off scot-free with no burglary charge. He was convicted of burglarizing the apartment.
So that's what makes me think at times that your argument is really a unit of prosecution argument. One burglary per incident.
Right. Well, and what this court has also said is the unit of prosecution is how many entries into the protected structure. And the way the government is trying to get a second burglary here is to say there was a second protected structure within the home. So there's no question you've got the entry into the home. That's your first entry. The government's saying a room used as a sleeping apartment means any bedroom. So what the legislature was trying to do in 1967 was to depart from centuries of burglary jurisprudence and create a wholly unprecedented and wholly unlimited new doctrine that additional counts of burglary could accrue based on every entry into every bedroom within a dwelling. And that they didn't explain that that's what they were going to do by using this awkward term, room used as a sleeping apartment. We think there's a much clearer explanation of what the legislature was doing, which is simply codifying the long existing common law tradition of treating independent standalone dwelling units like, not standalone dwelling units like dorm rooms and rooms in boarding houses as separately burglable dwellings. Had there been a room like that inside Ms. Belton's apartment, and had Mr. Williams broken into that room, then you would have two separate entries. You would have two separate units of prosecution. That clearly isn't the case here. There's no dispute that Ms. Belton's bedroom was not a separately occupied dwelling unit. And so for that reason, the first degree burglary conviction has to be vacated.
Thank you, Ms. Terrell. Mr. Lenners?
Thank you, Your Honor. Good morning, and may it please the court, Dan Lenners for the United States. If I might start where Ms. Terrell left off, We do think that this is a relatively straightforward unit of prosecution decision with regard to the burglary charge. Courts across the country have interpreted burglaries to occur when a person lawfully enters a residence or other structure and then subsequently enters a room to which he has no authority to enter. Courts have found multiple burglaries to occur when a defendant enters a hotel and then subsequently burglarizes multiple rooms, or enters a business and then subsequently burglarizes multiple offices.
Mr. Lunars, that seems to be the distinction to a degree that Ms. Terrell is drawing here. This wasn't a hotel or another facility which pursuant to our laws is required to allow people to come in, so that there is no unlawful entry into the into the institute or the building itself. It's a hotel, it's a business. People are invited in, encouraged to come in, but that there is a recognition that within those buildings, there are privacy issues, or people have privacy rights that have to be protected, and personal property rights that need to be protected. And that at that point, there could be a burglary of a room used as an apartment or a sleeping room, or an area that is what we would call protected by those privacy issues. I don't understand why that argument that you're now making is inconsistent. There may be statutes that are written differently. And are you suggesting that our statute is written in a way that is consistent and that we should be persuaded by other jurisdictions who have a similar statute in interpreting it in that way?
I think that this court should be persuaded by decisions from other courts that allow multiple burglary convictions, both for the initial unlawful entry to, say, a closed business, and then for subsequent burglaries of locked offices within that business. In fact, in Jennings in 1981, this court affirmed 3 burglary convictions. The first was for the burglary of what was called a tourist home, which I think was in fact a whorehouse, as a whole, and then subsequent entries into 2 rooms within that house. And this court affirmed 3 burglary convictions. And so we think in that respect, the California Supreme Court's Garcia decision is quite compelling, in which it has a statute that similarly lists multiple places that can be burglarized that seem to be standalone, protectable private places. And it said that it is a fact and circumstances, case-by-case decision as to whether a subsequent burglary of an interior room or interior structure may occur when the defendant has burglarized the exterior as well. And we think that, and it specifically said, if the subsequently entered room provides a separate and objectively reasonable expectation of protection from intrusion relative to the larger structure. And we believe that occurred here when Ms. Belton, while under attack from this defendant, locked her bedroom door and barricaded it against him, thus showing a objectively reasonable expectation of additional privacy from his vicious attack.
Why would
Do any of the cases from other jurisdictions that you rely on use a phrase like the peculiar phrase, sleeping apartment?
So far as we can tell, only the North Carolina statute and the DC statute use the phrase sleeping apartment. In 1920, the DC Circuit, as predecessor to this court, used the term sleeping apartment the way we would use bedroom today. In a civil case in describing a 4-story townhouse, it described the owner's sleeping apartment on a full or separate from where the children and their nanny slept. And so I think that this case is not so much about the proper interpretation of sleeping apartment as it is about the unit of prosecution. Because in these other cases where a person has entered a residence lawfully been invited in, but then subsequently say broken into a bedroom, the court's reasoning is that that bedroom is a dwelling, and that the person has burglarized a dwelling. And so that's why we think this is more a unit of prosecution like the Garcia case out of the California Supreme Court than it is a pure statutory interpretation case. And if the defendant's focus is on privacy interests and what is protected, what is the invaded protectable interest in any particular burglary prosecution, this court has already said that a person who burglarizes a house, leaves, comes back in to steal more stuff, leaves, comes back in to steal more stuff, leaves, has committed 3 burglaries. But that's the same privacy interest every time they enter that house. It is a unitary private house. But this court in Byrd said that that may be properly charged as 3 burglaries because there were 3 entries. And so if you're focused on the privacy interest, it's clear that a person can have a privacy interest in his home as a whole, as well as a greater or separate privacy interest in a locked and barricaded bedroom, such that these 2 convictions stand. And there's clearly a fresh impulse or a fork in the road that this defendant faced. You know, we didn't cite those cases in our briefs, but the fresh impulse cases talk about when a defendant has been convicted of 2 violations of the same statute, this court uses a fact-based analysis to determine whether separate criminal acts have occurred. And one of the things this court has looked at is whether the defendant had a fresh impulse. This person, Mr. Williams, clearly did. He burglarized the house, assaulted Miss Belton, assaulted Mr. Brown, and then after Miss Belton hid in her bedroom and started calling 911, he chose to break into that bedroom as well and assault her further.
Mr. Lenners, let's talk about a fancy cocktail party at one of the bigger houses in the District of Columbia. A guest is invited, and being an ungrateful guest, he slips upstairs and enters 5 separate bedrooms, stealing valuable property from each of them. He didn't have to break any locks to enter those bedrooms. Have any burglaries been committed? And if so, how many?
I think in that circumstance, 1 burglary has been committed, because if the doors are open and there's no objectively reasonable separate expectation of privacy as to the 5 bedrooms, but the person has not been allowed into those bedrooms, that the person has committed the single burglary of the 5 bedrooms. Much like if a person breaks into a house and doesn't enter through any further locked doors, but simply goes room to room, that's a single burglary. And courts across the country have recognized that as a single burglary. It's when the spaces within the larger space are set off from it, such that there is this objectively separate indication of privacy or security, that another burglary occurs. And so the California Supreme Court, for example, in Abilés, found that a boy who was invited into his mother's house burglarized her bedroom. When she told him to get out, he left and came back in and assaulted her, and then burglarized his sister's bedroom because he broke the lock on the sister's door. And so the sister's door had this separate, objectively reasonable indication of privacy. As to the house as a whole, which the court found that it need not decide whether he had authority to enter. And so
even though our statute says you can commit a burglary by entering without breaking, under your analysis, you need to break a lock to separate the privacy interests.
So I don't think you have to break a lock to commit a burglary, but when looking at the facts and circumstances for the unit of prosecution question, I think that requires something more than merely entering several different unlocked rooms.
And in your theory, has he burglarized the bedroom or the dwelling in its entirety?
I think that under our view, that defendant would be properly charged under either statutory provision, either the dwelling as a whole, which, courts from across the country have found that when a person's invited into a house and then burglarizes a bedroom, that is properly charged as first-degree burglary of a dwelling, or under the sleeping apartment provision of the DC code. We equate, and the DC circuit has equated sleeping apartment with a bedroom. And it's a very broad provision. It's a sleeping apartment in any building. So it's not separate from dwellings. Any building incorporates dwellings. And so we believe that it's appropriately understood as a bedroom as well.
Mr. Linares, you stated that North Carolina is the only jurisdiction that has a statute worded similarly to ours. Is there any case from North Carolina that has interpreted their statute as broadly as you would ask us to interpret this one? I know that Hobgood is the case relied upon, and in that particular case, that was, as we kind of traditionally think of, a sleeping apartment. Somebody was in a motel. Therefore the motel invites people in. You're not going to be burglarizing the entire motel by going into the lobby, but you are, if there are rooms that are separate and sleeping quarters, those can be separately burglarized and take and carry separate charges. But in that instance, that's exactly what occurred. Has North Carolina looked at this statute? And again, we are a town, a city that, of course, relies on tourism. I mean, there is a lot of reason to protect people's individual property and to make them feel safe, and to certainly ensure that individuals who are in all of our hotels and they are protected from these kinds of activities. So my really question is, that last part was dicta. My question is, why has North Carolina, looked at their statute and interpreted it as broadly in any case as you would ask us to interpret it here?
Not that I'm aware of, Your Honor. I have to confess I didn't write our brief, and so I haven't read all the North Carolina cases, but the author of our brief, I trust, would have found it. The defense has not cited any North Carolina cases taking a narrower view. So I suspect they haven't addressed this precise question, but Ms. Terrell will correct me if I'm wrong. I would like to amend my answer to Judge Fisher's question about the breaking. I think breaking can be indicative of a separate privacy interest that is subject to a second prosecution, but it's not the only way that can be indicated. And I would point to this court's Jennings case, in which it upheld the burglary of the tourist home as a whole, but also the separate burglaries of the 2 rooms that were used by prostitutes to conduct 15 to 20-minute transactions. So now those separate burglaries, the court found to be second-degree burglaries of a room, but the court nonetheless affirmed multiple convictions in that instance, without admittedly addressing the precise argument that Mr. Williams makes here. I see that
cross-examination.
Our view is that what was kept out was so highly inflammatory and had such limited use to the defense, particularly given all of the ammunition they had to effectively cross-examine Mr. Brown, to make him look like a liar, to make him look biased, to make him look like he's just willing to try to shift the blame to anyone else other than himself, that there was no error at all because the judge appropriately exercised her discretion under Rule 403 to keep the highly inflammatory details of this slap.
Mr. Linares, Ms. Terrell argues, bias aside, this was direct opportunity to confront his story, his reasoning, his excuse for why he would not have been the one to have committed this crime, because of his depression for what at least the defense believed and proffered was a misrepresentation as to his the basis for his alleged depression. Why, even if we don't go on the theory of bias, isn't that testimony, isn't that cross-examination appropriate? Let's forget bias. Let's just say they were responding to his direct testimony.
So the defense was able to cross-examine him with his grand jury testimony and get him to admit that he was able to see his child. So he went back and forth. He said, I wasn't able to see my child. I wasn't able to be there for the birth. And then later on, he said, I was able to see my child. He said that twice, and the defense said out loud to the jury, he's changing his testimony. There was also ample testimony that when he drinks, he gets angry. Not only did Miss Belton say that, but they talked about this incident in November 2016, where he was drunk and angry, confronted her and threatened her at the hospital, and then went home and destroyed 2 TVs, poured bleach on her clothes, and she called the police for an escort home because she was so afraid of him. He denied much of that. And the defense showed him to be a liar in that regard by playing body-worn camera video of him admitting things that he denied on the stand, and then Miss Belton saying, no, these things are true. And so the defense had ample ammunition to show that he didn't tell the truth, that he wasn't completely forthcoming or honest about what had happened at the hospital, that he was in fact angry and drunk. And you know, he even admitted at one point on December 15th on page 203 that upset and angry for him are the same thing. There's a confusing colloquy in which he denied being angry, but admitted being upset, but then admitted, yes, I was. When they said, oh, were you angry? He said, yes, I was upset. And upset is the same word he used for how he felt on the date of the incident here. So the defense had ample ammunition and did in fact argue in closing that he was angry on the date of the incident here, that he assaulted Miss Belton, not Mr. Williams. And Judge Thompson, you asked about the aunt's testimony. The aunt didn't testify, but there was this 911 call that Miss Belton made where she repeatedly said, Eugene, just go. He's attacking me, Eugene, go. And Eugene was the defendant. And so you would have to believe that to believe the defense theory, you would have to believe that while Mr. Brown was beating her such that she needed surgery on her ear, that she wasn't saying, Eugene, help me. Eugene, save me. She was saying, Eugene, the police are coming. You just go. The person who could help her, just go. And that Williams, despite being innocent, is the one who fled the scene. And that Brown, despite having committed this assault, is the one who committed it. And not only did he commit it, but he and Miss Belton immediately blamed Williams. Immediately identified someone else as the attacker, and then kept up this story for 1.5 years. And so that's so far-fetched. And there was no objective evidence that Mr. Brown, as opposed to Mr. Williams, was in fact the attacker. And you had this 911 call showing exactly the opposite, that even if there was some error, Judge Washington, we believe it was harmless under any standard.
Thank you, Mr. Lenners. Ms. Terrell, very briefly, please.
Yes, thank you. I'd like to just briefly touch on both issues. The government shifted away from the argument in its briefs to try to suggest this isn't on burglary a pure statutory interpretation case. And that's because the statute is clear that the first-degree burglary statute does not apply to ordinary bedrooms within an integral dwelling. Room used as a sleeping apartment, according to its plain text, the legislative history saying that that statute was intended to apply to dwellings, the pre-existing common law that it was trying to codify clearly refers to a separate room, a separate dwelling unit within a larger structure. This isn't a statute like Garcia. It doesn't say rooms in the first-degree burglary statute. It says rooms used as a sleeping apartment. And I just want to flag that, we relied on Garcia to make this sort of separate fallback argument that even if room used as a sleeping apartment could be interpreted to mean any and every bedroom within a dwelling, even then, under the logic in Garcia, still, you would need some indication of a separate security and privacy interest, for which, as we've argued in our brief, the mere act of locking the door in the moment of this intrusion into the home wouldn't suffice. But this court doesn't need to get into that at all, because the question here is answered by the statute itself. Did Mr. Williams enter into more than one separately protected structure covered by the first-degree burglary statute? He's been convicted of entering into the dwelling for coming through the front door. There was no other separately protected structure. There was no room used as a sleeping apartment within that dwelling for him to enter. And nothing that he did, and nothing, no fork in the road, and nothing that Ms. Belton did could change the fact that her room was not a separately occupied dwelling unit. And the government has not pointed to any case in the history of burglary in this jurisdiction or any other where a court has upheld duplicate burglary convictions for entry into both a ordinary single family dwelling and a bedroom within that dwelling, unless the bedroom had indications that it was a separately occupied dwelling unit. And Jennings is no different, where you have a hotel, the rooms within a hotel would qualify as separately occupied dwelling units, rooms used as a sleeping apartment. I believe Judge Glickman reached the same conclusion about separately occupied apartments within a subdivided row house just last year in Ruffin. That's the obvious meaning of the statute, and that precludes a first-degree burglary here. As to the cross-examination question, the strength of Mr. Brown's bias to shift the blame for this second domestic violence assault in as many days and fourth in just 2 years wasn't captured by the admitted evidence that he had a pending assault with a 6-month penalty. But apart from that, the defense was wholly precluded from rebutting Mr. Brown's insistent claims that he was simply too depressed to be angry and violent. And whatever he might have said about the word upset in that quote that I read you, he made very clear, depressed and anger are two different things. I said I was depressed because I couldn't see my child. I was never angry. The defense was given no opportunity to rebut that assertion. And so that cannot be held.
Thank you, Ms. Durrell.
Thank you.
We appreciate your argument. Mr. Lenners, thank you for your argument. The case will be submitted.
Thank you.
Bringing in the next case.
Mr. Lapidus, it looks like you may win by forfeiture here.
Thank you, Your Honor. I believe Mr. Hoge will be connecting soon.
I see Mr. Hoag there.
There we go.
The lighting is very bad. Sometimes you're entirely in the dark.
There we go. Right in front of them.
Okay. Are you comfortable, Mr. Hoag?
Mr. Hoag, can you check your audio?
Hello, can you hear me?
Yes. Can you hear us?
I can hear you, but for some reason, I'm not getting you any video on my computer screen. I'm only getting it on my telephone.
Well, it's not that important that we see you, but more important that we hear what you say. Are you willing to proceed in those circumstances?
Yes, I guess so. So you're able to see me. I'm able to see you, Judge Fisher, nobody else on the court.
There's
You may
probably
have
a
to switch to gallery view.
I'm doing this on my phone, which I'm not, I've got somebody helping me. Where's the gallery view? Somebody more knowledgeable than I am is trying to help me do this. And I'm happy to say that hide my video in gallery view. I don't think that's it.
I don't think you can do it from
My computer's,
okay, there you go.
oh, okay, there we go. Looks like I'm on gallery view now, thanks to my intrepid assistant. It's a little strange, Your Honors. My computer screen is saying, please wait, the meeting host will let you in soon. That's been what I've been seeing since 9:10 this morning. But at any rate, shall I just put the phone like that? I mean, is that acceptable to everybody?
Let's give it a try. Let me call the case and then we'll proceed. We will now hear the case of Timeco versus Werner Friedman and Pascal LLC, 19 CV 176. Mr. Hoag, when you and I started out in Superior Court 45 years ago or more, we didn't have to worry about these things, did we?
It was a different world, Judge, for sure.
Please proceed.
Thank you very much. So may it, I'm tempted to say, may it virtually please the court. And Mr. Lapidus, thank you for the opportunity to argue the case. I represent Timeco Inc., the lessee of premises at 1251 53 to 53 4th Street. In January of 2014, a fire severely damaged those premises. The lease was held in the name of my client, Timeco Inc. It was running a wholesale meat business out of that premises. So critical to those facilities were an electrical system and a refrigeration system, allowing them to store copious amounts of meat in freezers and lockers. Timeco signed its original lease for this building back in 1997. Timeco is wholly owned by an individual by the name of Hushang Momenian, who has been in the meat business for many, many years. In 2005, there was an attempted assignment of the lease from Timeco to a new entity called Country Choice. The
Mr.
reason for
Hoag,
that,
if you'll
yes.
forgive me, let's jump into the meat of this case. We've read the facts. So you blame this outcome on the trial judge. Could you help me understand what the trial judge did that deprived Timeco of a verdict in its favor?
It made an implicit but not articulated decision on a motion for election of remedies that I don't believe the judge intended to prevent Timeco from asserting its claim for loss of repairs in the event there was not a legitimate assignment of the lease from Timeco to Country Choice. There is no place in the record, Judge, where either Mr. Laturi, the trial lawyer for Timeco at the time and for Country Choice, made a specific election not to pursue Timeco's claim for repairs. But, and the judge never ruled.
One of the difficulties is that the judge showed jury instructions to both counsel. Both counsel said, we're good. He showed the verdict form. I think counsel had actually prepared the verdict form. He asked them to look it over. They said, those are fine with us. And if your client thought he was still pursuing a claim for repairs on behalf of Timeco, those are curious responses to those inquiries by the trial court.
So I would respond in this way, Your Honor. As you know, I was not the trial counsel. You know, in a perfect world, the record would have been preserved better by trial counsel. Nevertheless, we argue that it was preserved sufficiently that the matter should have been spotted by Judge Rigsby, the trial judge, and some further colloquy needed to occur as to what was going to happen to Timeco's claim for a cost of repairs in the event the jury found that there was no assignment. We've in our reply brief, Your Honor, we've cited Superior Court Civil Rule 51D2 that talks about a court may consider, talking about your Court of Appeals, a plain error in instructions that have not been preserved if the error affects substantial rights. And we certainly do believe that this error affected the substantial rights of Timeco. Now, Your Honor,
but the question for me is, whose fault is that? Was it the judge's? Was it anything the judge did? Or was it simply an oversight by your client's former counsel?
I don't think it was an oversight, Your Honor, because counsel had spent the entire case. We're talking about a 5-day trial. Mr. Laturi had spent the entire case arguing about the cost of repairs. There had been experts talking about the cost of repairs. And one of the salient facts in this case is that the landlord's own expert acknowledged that there was a need for repairs. Now, when it came down to that critical colloquy that we quoted at length in our opening brief, to be sure, there was some confusion, but I would point to a very specific place, if you'll bear with me. At pages 7 to 8 of our brief, we quote from a colloquy that appears in the appendix between 921 and 927. This is the colloquy about election of remedies. And the judge asks, let's go through this systematically. What exactly are you asking for and from whom? Country Choice, you are asking what? Mr. Laturi, for lost profits. And then the judge asks some follow-up questions as to that. Laturi says, and for extra expenses, and while still paying rent at the original lake location. And then the judge says, okay, and Timeco. And Mr. Laturi says, Timeco would simply be for the repairs that are necessary at the building. The judge, in making a ruling on that, which we quote at page 9 of the brief, the opening brief, talks about the need to elect by Country Choice between loss of profits and loss of rents. And that's a totally justifiable decision by the judge, that is an election that needed to be made because those would clearly be irreconcilable claims. What's important here is that the claim for Timeco is not irreconcilable with the claim for lost rents or lost profits by Country Choice. We're talking about different matters. And Mr. Lettieri made that very, very clear. And by the way, Judge Fisher, I'll have to respectfully take issue. I don't believe that Mr. Lettieri created that verdict form. There's a passage where Mr. Lettieri makes reference to the fact that he is working on a verdict form, but the judge then later on makes reference to a courtroom clerk whose name I believe was Alicia, who was going to go out and create the form. Now, you know, should the trial lawyer have specifically objected to that verdict form at the time that it was being passed around by the courtroom clerk at the close of the case? Yes, of course. From our point of view, the answer to that is yes. But the question is, I think before the court, was that failure fatal to Timeco's fundamental right to have its claim? And it's important to remember that this claim for loss of repairs was what started the case. If you look at the various complaints, and specifically the third amended complaint that's in the appendix, it is for cost of repairs. I went through, and if I can find my right note here, in various places, you know, Mr. Lettieri, oh, I'm sorry, I forgot to reserve some rebuttal time. Somebody's just reminded me. I'd like to reserve 3 minutes of rebuttal time, please, if it's not too late to do that. But just bear with me 1 second. Yeah, in various places, at 923 to 924 of the appendix, Timeco elects the cost of repairs, says Mr. Lettieri. The same thing is true at pages 925 to 26. The closing argument of Mr. Lettieri, which is 946 to 955 of the appendix, it's an extensive argument by Mr. Lettieri as to why Timeco is entitled to the cost of repairs. And if you remember, there was
here's the problem for me, Mr. Hogue. You seem to be saying now this was an oversight, the way the verdict form and the instructions read, and the judge failed to catch it. What I'm having trouble understanding is what ruling did he make that resulted in Timeco not having a claim for repairs?
And that's, I think, precisely the point we've made in our opening brief, Your Honor. He did not make a ruling to that effect. There is no place in which he made a ruling. He made a ruling that Country Choice could not claim both loss of profits and loss of rents. He did not rule that Timeco was thereby prohibited from making its claim that was the original claim in this lawsuit for the cost of repairs. And in fact, if you look at the judge's instructions, Your Honor, at appendix, and I'm sorry, this has got me shuffling notes a little bit more than I normally do, so forgive me for that. Yes, appendix 1007 and 1009, in the judge's instructions to the jury, he says, and I quote, "This is a dispute involving the obligation to complete repairs." So, you know, that instruction, which appears in two places, at 1007 and 1009 of the appendix, shows that the judge had it in his mind that this was going to go to the jury on the question of Timeco's right to get the cost of repairs. There were some tangential issues involving some CNA first-person claim money that the landlord was claiming was misdirected by Mr. Momenian or was somehow duplicative. But the judge had previously ruled in the summary judgment ruling decision that that is an issue that should go to the jury. So there is no place on the record that I can find where this judge has said specifically, Mr. Lettieri, on behalf of Country Choice and Timeco, you need to both decide between Country Choice's claim for lost rents and lost profits, and also between Timeco's claim for cost of repairs and the various Country Choice claims, because those claims are irreconcilably inconsistent. Indeed, under the Saunders case that we cite at page 10 of our brief, it is not an irreconcilable difference. So I don't know if I'm answering your question to your satisfaction.
Well, I'm
Your Honor.
confused now, Mr. Hoag. What is it then that kept the jury from getting to the question of repairs for Timeco?
The verdict form. The verdict form, question 1, and you have that in the supplemental appendix that was submitted by Mr. Lapidus. The first question says, and I'm paraphrasing a little bit, was there a valid assignment from Timeco to Country Choice? If you answer yes, go to the next question. If you answer no, your job is done, you may go home. That's what prevented the jury from deciding the question of Timeco's cost of repairs. And that was a fundamental, dereliction, if you will, not an intentional one.
Okay, well, I guess the answer to Judge Fisher's question then is it's the trial court's designation of that form as the form that caused the problem then. We're still
Yes.
trying to focus on what did the trial court do wrong here?
It's the
And
form.
what's your answer to the question when counsel for Timeco said something to the effect of the verdict form looks fine to me? Why was that not a forfeiture on this issue or a waiver?
Well, first of all, I don't believe there's any place in the record where the counsel did say the verdict form looks fine to me. We've got the entire transcript of the trial, and he never says that I've seen in the record. What he does say, and we quoted in the briefs, is I've got a verdict form here that I've been working on. And that's in the context of the discussion about Timeco's claims and Country Choice's claims. And then later on, after the discussion about the election of remedies, and the judge clearly says Country Choice doesn't get lost profits and lost rents. That would be a windfall. And remember that the whole concept of election of remedies is to prevent a windfall. Here, there was the opposite of a windfall. There was the wiping out of a legitimate claim without the ability of a jury to deliberate on it. So the answer is, the judge after that decision says, I've got my courtroom clerk and she's going to work on the verdict form. And that's all we know about what happened with that verdict form. There is nothing.
Mr. Hoag, I'm looking at transcript, and the court, at least according to what I'm reading, asked the parties. He says, all right, all parties that were present before the recess are once again present. Counsel, you both agreed to the final jury instructions. Is that correct? Plaintiff, Mr. Lettieri, yes, Your Honor. Defense, yes, Your Honor. No objection to the final jury instructions. No, Your Honor. No, Your Honor. The court then says, and then we have a verdict form that mirrors. I have had an opportunity to review it. It mirrors the jury instructions. Any objection, counsel? Mr. Lettieri, no objection. Any objections, defense? Mr. Lapidus, no, Your Honor. So there is an opportunity, because again, we can find plain error, or we can review under plain error, but then the error has to be plain and obvious, and it has not, and certainly waiver, as my colleague has suggested, is something that we also have to take into consideration. But we do review for trial court error, and under circumstances where the counsel has endorsed a trial court position, as opposed to court just not realizing a mistake was made, we look at those a little differently. How should we look at it in this case?
Well, Your Honor, the error was fundamental. And as I said at the beginning of this argument, in a perfect world, Mr. Lettieri would not have given that response. We can't revise history. It is what it is. However, the question is, after all of the record that had been made in this case through over 1,000 pages of transcript, over and over and over and over again, talking about the cost of repairs, Mr. Lettieri in his closing argument talking at length about the cost of repairs, the judge instructing on this is a claim for the cost of repairs. So Judge Fisher, to get back to your original question, what should the judge have done? I suggest that the judge should have said, wait a second, I'm looking at this form and I'm not seeing here what happens to the claim for Timeco. I don't see why Timeco doesn't get to have its day in court on the cost of repairs if the jury finds that there is a lack of an assignment. I wish Mr. Laturi had objected to the form, but I can't change that.
Thank you, Mr. Hoag. We'll give you a couple of minutes in rebuttal. Mr. Lapidus, do you have a different view of things?
I do, Your Honor. I'm going to try to stand up. If I can't get this camera working, I will sit back down. Nope, I disappear. If it works, I'm sorry. I found it more comfortable standing up in these situations. May it please the court, in this case, Timeco has raised an issue. It's claimed that it should have been allowed to seek recovery for the cost to repair the landlord's property. And in this instance, as I think was alluded to in the first 15 minutes of this argument, the Timeco here is not seeking relief from a ruling of the court. Rather, it's seeking relief from its own unsuccessful trial strategy. Here, the record, the case law, the briefs even provide no basis for reversal of the judgment for the defendant in this matter. First,
as Mr. Hoag says, this is a pretty fundamental change in the way the case was tried. Maybe it's the trial judge's obligation to have paid closer attention and to have said, wait a minute, is this what you guys really want?
Your Honor, I disagree. At first, I think in all instances, it's counsel's responsibility to advocate and make sure that their arguments are there. The judge makes rulings on matters that are brought to their attention, but the counsel has the primary obligation. More importantly, there's lots of different trial strategies that were made during the course of these proceedings. If you look at the complaint, both the complaint from Timeco and the intervener's claim for Country Choice, both claims had identical theories of recovery. You know, both were claiming the same lost profits, lost rents, property damage on both sides. And then when we get to the end, and it was my understanding too that Country Choice still had a claim for lost profits. I think this comes in towards the beginning of this election remedy, around 923. If I find the exact site, I'll let you know. But where we're discussing, saying Country Choice has all three remedies: lost profits, lost rent, lost the property repairs, and plaintiff, and I think this is pages 924 to 926, Mr. Lettieri says, no, we're dividing it up. So they made an election even there that Country Choice was no longer pursuing its claim for property damage. It was only going to be, at that stage, before the ruling on election of remedies, it was only going to be a Timeco that does that. So there's lots of different elections that get made as we go through these proceedings. And you see this again as we go through the court's ruling. And I think it's important. The court never ruled, as I think I heard Mr. Hoag even agree, the court never actually ruled Timeco cannot pursue its claim. This is another of those strategic decisions. Why plaintiff makes those strategic decisions, I don't know.
I frankly have a hard time seeing this as a strategic decision as opposed to an oversight.
Your Honor, I don't know. To me, it seemed like a strategic decision. They were calculating the claim. Inherently, it is inconsistent.
What would plaintiff have had to gain by abandoning the claim on behalf of Timeco?
Rent through the end of the lease. A claim for lost rent through the end of the lease. It's inherently inconsistent. If they're going to get a claim for to recover the cost of property damages, that means they are going to go back in and repair the property and resume operations at that property. If they do that, then their claim, and that was discussed on page 941. If they do that, then they don't get rent or lost profits, whichever way they selected. They don't get that claim afterwards. So that's what they had to gain, and that in fact is what was argued here, Your Honors. Mr. Lettieri in his argument claimed lost rent through the end of the lease. I know he talked about two different formulations: $12,000 a month through September 2020. Alternatively, give us $12,000 from this date, and then for the remainder of the period of time, $6,000, which in effect is, he says, we're abandoning the lease, so we're not going to be out of pocket the whole thing, only half. But in any event, under the formulation that was selected, he chose to pursue rent as if the property was never repaired. He never took that money and put that back in and made that investment. And instead, he sought lost rent through the end of the lease. So that's what he has to gain in making this this decision.
But Mr.
Yeah.
Lapidus, would it have not ended up with the same opportunity for a remedy had the extra question in the verdict form been asked? If in fact you find there was not a valid assignment, then do you find that Timeco's entitled to X? Why would that be sort of an election or an inconsistent way of presenting this case to the jury, as opposed to the way it was presented to the jury in the verdict form?
Because it's inconsistent facts. The fact of repair assumes that there is no rent
Correct.
through the end of the lease. So you can't, you have to argue different facts. To argue the one claim, you have to say, well, then you need to assume we move back in at a certain date. So it's inherently inconsistent on the fact pattern.
But do you agree that there's no jury instruction and there's no verdict form that would have allowed the jury to give Timeco rent to the end of the lease?
As ultimately, as what was submitted to the jury, yes. I mean, that's precisely what the election that was made by the plaintiffs. They elected that they would only pursue the claims of Country Choice. I believe it is in the jury instructions, where page 1006 to 1007, where the plaintiffs have elected to only pursue claims on behalf of Country Choice. Specifically, Country Choice has elected to assert it has only one business and only seeks any extra rent and rent-related expenses incurred for the temporary location and the old location. So, yes, I agree, Your Honor. It wasn't in there because they made the election to only pursue the claims on behalf of Country Choice, the lost rent through the end of the lease, and that was the affirmative decision that was made. And I think it's consistent with the law. It's consistent with the arguments that were made. I know counsel in his argument and even in his reply brief discussed how throughout the case there was argument and discussion about the obligation to repair. Well, that's the fundamental starting point for this alleged breach of contract, is whose obligation is it to repair? He has to put on that evidence regardless of what claims are being made. He has to make those arguments in order to say there was a breach. He's got to suggest it was landlord property and landlord obligation to repair. So those arguments have to be made regardless of what theory. That's the underlying portion of the operative portion, if you will, of the breach of contract theory. I mean, to say, hey, we have all these decisions. They talked about the loss of profits. They brought in an expert, Steve Perry. They clearly affirmatively made that decision. We're not pursuing lost profits. So the fact that you discuss something throughout the case doesn't reflect a strategic decision or something that comes up later. The fact that it's discussed at an earlier point in time. Here, they did have to talk about the obligation to repair, because it's the fundamental theory of their breach of contract. So it has to be discussed, but he never argued or put in any numbers in his closing. He never suggested this is what it's going to cost. We're going to do these repairs. We're going to make none of it wasn't there. It wasn't made. It wasn't preserved. And frankly, from the verdict form, from the jury instructions, it was waived. Not waived. It was an election. They made this strategic decision, not to pursue it in this matter. And I think there's another issue that I talked about in my brief we haven't discussed yet today. I think standing is very important. I mean, one of the big issues here is, how does Timeco or any of the plaintiffs for that matter get to make a claim for the cost to repair the landlord's property damage? These are unincurred costs. There's no dispute.
Could you help me with this question on standing?
Yes.
Assume that we decide to send the case back. Is standing a question that we can properly address now? Or isn't that a question for the trial court if we allow any further proceedings?
I think it can be decided either way. I mean, I think standing is it's a jurisdictional question. Yeah, it's a jurisdictional question. The court can raise and address at any time. So I think it can come here. It can be decided here. And I think importantly, it would be a waste of court time resources to send it back just for that, to have that issue because it's so futile. I mean, it's undisputed. The costs weren't incurred. The case law is clear. And I think you find this even in the reply brief, but the case law is clear. There has to be an interest to pursue the claim. The claimant has to have some type of interest. The tenant, the case law says, tenant doesn't have the right property interest, the requisite ownership interest to recover damages to real property. And that's, you can see that in the Gaetan case and the Robinson versus Samuel Boyd case.
Is the record so clear that you think standing is a question of law? Or would we have to engage in some fact finding in order to reach the conclusion that Timeco does not have standing with respect to the repairs?
Your Honor, I don't believe there is an issue of fact that you would. I don't believe you would have to engage in fact finding. The law says you have to have an interest in the property. Even when you look at Gaetan, and they said it could be trespass, or it could be nuisance. It's the tenant's nuisance. The tenant's nuisance. The injury to the tenant's interest in the property from the trespass or out-of-pocket expenses. It's the interest the tenant has. Here, it's undisputed. Even in the reply brief, they open up saying Timeco is entitled to the cost of repairs yet to be performed at the property. That's reply brief page 1. There is no dispute. The claim that they're seeking here is property damage that has not been incurred. It's undisputed. It's not out of pocket. It's undisputed under their theory. I mean, if it's tenant's property, they lose the case as a matter of law. So we won't, because there's no breach of contract and no obligation. So they're saying it's landlord property. If it's landlord property, they have no interest, and they haven't spent the money to make any of these repairs. So there is, as a matter of law, there's no facts that the court has to review. As a matter of law, it's barred. And I think I'm
not understanding your argument. Why didn't Timeco have standing to pursue repairs to the property, to restore the property to the condition that would have made it possible for it to continue its business there for the contemplated term of the lease? Why did it lack standing?
Because these are it's a tenant, not the owner of the property. And these are unincurred costs. This isn't money that it's spent, as Gaetan and the Robinson case discussed. These are unincurred costs. In fact, you have no. I mean, in this situation, here we are on June 23rd with a lease that ends September 2020. Plaintiff will likely never. By the time this case gets sent back, and with COVID and we have a retrial, the lease will be over. Plaintiff will never incur those costs, which gets us into a situation where he's out of the property seeking money to repair property he's no longer in. There's frankly, just when you read the case law again, they talk about a tenant lacks the requisite ownership interest to recover damages to real property. Gaetan.
I mean, are you suggesting that the verdict form was just fine in not giving the jury a way to award anything to Timeco because Timeco lacked standing in any event? Is that part of what you're telling us?
No, I'm not making that argument here necessarily. I'm saying there is no I guess I am. I'm saying.
Well, I was going to say, well, doesn't that kind of show the plain error of this situation? I mean, why should the court have approved a verdict form or drafted one that left one party without standing while allowing the party to remain in the case? There's just something not right about that circumstance.
Well, the verdict form was jointly drafted. I was there, and it was jointly drafted with counsel, and we worked with the judge's clerk because she had the computer.
Right, I don't dispute that, but the court put its stamp of approval on it. The court said, okay, I'm using this form.
Correct.
And it did that while allowing Timeco to stay in the case, even though according to you, it had no standing, certainly at that point, even if it ever had it.
I'm saying that the decision was correct because it lacks standing. The verdict form went forward not because there was no standing. I don't think that ruling. I don't think that ruling was ever made. I think the verdict form went forward and is correct because that's what the plaintiff elected to have. It wasn't that a decision was made. We're leaving Timeco off because it has no standing. My argument is now it doesn't matter. Timeco doesn't have standing. But when the decision was made, the issue was they've made that election, and that's why it's correct. And they've waived that right. It's not, or they abandoned their claim. It wasn't that they. It's correct because of the lack of standing issue. It was because of the election and the way they chose to proceed as set out in that jury instruction.
So you're claiming that the error, that any error at this point is harmless.
I am, Your Honor. I am, Your Honor. And I would add that, even on the record, as I said in the brief, and I'm not going to go through it because I see I'm out of time, even factually, to send it back would be a harmless error. No reasonable jury could find otherwise.
Well, why is their reliance on Section 19 of the lease agreement not enough to provide them with sort of this remedy, this right? Section 19, which talks in terms of appellee's obligation to repair the property.
The leased premises, Your Honor. So, and the leased premises is what was rented. It's not the landlord. It's not the tenant's property. It's the landlord's property, and that's the obligation to repair. So you have it's not just because it says Section 19 in the lease. First question is they have to establish that it's landlord's property that the landlord was obligated to repair. So that's the first step. And then the second step is, what do we do? Where are we? Let's just say on September 30th, they get awarded some sum of damages to repair, and they're out. Then do we turn around and sue them back to get the money for the unrepaired property, since they never would have effectuated the repairs?
Let me follow up on Judge Washington's question. You agree that the lease obligated the landlord to make some repairs after a fire, correct?
Correct. To the landlord.
And
yes.
once the jury has determined that the lease has not been properly assigned to Country Choice, doesn't that leave you in the position where the lessee is still Timeco, and Timeco has a claim under the lease because it's paying rent and the place is not usable? The repairs haven't been made.
Not with the claim that was being pursued here, Your Honor. Here, the difference is plaintiff is elected to pursue the recovery through the end of the lease, the rents through the end of the lease, which necessarily means they've said we're not fixing the property. There's a line in Gaytan. It's just a part of a string site. I think it's on page 898, and it just says a tenant cannot recover property damage and rent abatement because it doesn't explain it, but the reason is it's inconsistent. You can't have both. You can't get rent abatement through or get all of your rents through the end of the lease and get the cost to repair the property. It's inherently inconsistent.
Is Timeco paying rent now on the lease?
Your Honor, Timeco is supposed to be paying rent now. I believe there is an issue there, but under the lease, yes, supposed to be paying rent.
Is the property in a shape that they could use it for their meat wholesale business?
Not without making the repairs that they're obligated to make to their property, which has been the holdup this entire time. It's their property.
So, and in your brief, you say that the things that need to be repaired do not belong to the landlords?
Correct.
But to Timeco?
Correct.
Okay. Well, we've heard your argument, Mr. Lapidus. Let's hear briefly from Mr. Hoag.
Thank you,
Mr. Hoag, we've gone well beyond your time, so if you'll be brief, we'd appreciate it. Can't hear you, Mr. Hoag.
Mr. Hoag, you have to unmute.
Still can't hear you. Mr. Green, is there anything you can do to help out?
It looks like he froze. Okay.
Can you hear me now?
Yes, thank you.
Okay, I have no idea why that happened, but that's certainly not unusual for me in my dotage. The answer to the last question is that the property is definitely not usable. There have been none of these repairs made. Timeco has largely been paying rent. There is an argument about 3 or 4 months of arrearages. There have been, but basically for the last 6 or 7 years since this has happened, Timeco has been paying roughly $8,500 a month, which includes the premium for the fire insurance. And that's one of the things that's been overlooked here, is that part of the rent that Timeco has paid all these years, and then Country Choice on behalf of Timeco, has been for the fire insurance proceeds. And so, the question about making a strategic election just doesn't really fit here. As one of you mentioned, Your Honors, there is no reason to make that strategic decision. It made no sense to make that strategic decision. The question of standing is, I think, largely a factual issue, but it's also a legal issue. The Gaitan case that Mr. Lapidus refers to so frequently is very, very distinguishable from our case, because you had no lease with paragraph 19. And importantly, you had no settlement agreement. Back in 2014, shortly after the fire, I'm sorry, put my phone down. Is that causing a problem? Oh, I'm sorry. Excuse me. I'm being told by my technical department that my phone was in the wrong place, so I apologize for that. Gaitan does not involve a lease with a provision that specifically addresses repairs. Mr. Lapidus says, well, the lease only requires repairs to the tenant's the landlord's property. That's an issue of fact. That was an issue that was debated extensively throughout the entire 5-day trial as to what property was repaired, what property needed repaired, whose duty it was. That's precisely the issue that was never given to the jury for its consideration. As Judge Thompson said, it's fundamentally, or suggested, it's fundamentally not doing justice to the lessee of these properties, of this property, Timeco. There is no place, I challenge the court, I challenge Mr. Lapidus to find one place where Mr. Lettery made a knowing and reasoned articulation of an election not to pursue the claim of Timeco.
Mr. Lapidus did quote a portion of the transcript, which I think says, we've decided to pursue the claims on behalf of Country Choice.
And that's where he's talking about Country Choice's claim for loss of rent, I believe. I know exactly the passage you're talking about, Judge Fisher, and that's where he's addressing Country Choice's claim for loss of rent. There's just no basis for that strategic decision, and it's inconsistent with what Mr. Lettery had been arguing throughout the duration of the litigation. So for that reason, we think.
Thank you, Mr. Hogue. We appreciate your argument. Mr. Lapidus, thank you. The case will be submitted.
Thank you very much. I'll try to sign off.
Thank you, Your Honors.
Okay. Well, that was.
You're still on camera, Mr. Hogue.
And probably fortunately muted.
Okay, judge is bringing in the second case,
Third, I hope.
or third case.
Good morning. Let me call the third case. Looks like everybody's here. We will now hear the case of Neal versus the Public Employee Relations Board, 18 CV 1253. Mr. Bradshaw?
Well, first, sir, I guess I'm not really in San Francisco, and I apologize. I'm having difficulty placing the appropriate background on the argument.
I'm happy to think that I'm in San Francisco this morning, so you may proceed. Let me call the third case. Looks like everybody's here. We will now hear the case of Neal versus the Public Employee Relations Board, 18 CV 1253.
Okay,
Mr.
council, if
Bradshaw?
you have a YouTube
Well,
stream,
first, sir, I guess I'm not really in San
then you need to
Francisco.
close your browser to YouTube. We have a feedback.
The appropriate background on the argument. Forgive me, sir. Let me cancel this.
I'm happy to think that I'm in San Francisco this morning, so.
Thank you, sir.
Okay, let's proceed.
Thank you. I do apologize for my background, but it is fun. Your Honor, the case involves Mr. or Sergeant Neal. Sergeant Neal is a decorated FOP official, employee. And this case is very straightforward as a complaint for money damages. It was based on a purely contractual dispute involved in the reimbursement for legal fees that occurred during the time he was the chairman of the legal committee for the FOP. This has been years in the making. The right is purely legal, and it carries with it a jury demand and a right to a jury trial. There's been an inordinate delay by the government in addressing the actual issues associated with this matter. That's why we're here. We simply want the opportunity to have a jury trial in this matter. I understand there will be issues of equitable tolling. That is certainly my position. And I
So
will
clarify this for me, if you will. Given the context in which this arose, and given the fact that the promise on which you rely seems to be found in union documents, can this be pursued as a simple claim for breach of contract?
Yes, because we tried many years ago. This matter began in 2010.
I know you tried, but were you entitled to try it that way? Why
Well,
isn't
sir,
it
I say we tried.
first and always a standard of conduct complaint?
It is, and we had to exhaust our administrative remedies before we could do anything else. We have done everything that could be done to address this matter before PERB. PERB took a very long time and did not and has never responded to the actual issues that give rise to this complaint.
Mr. Bradshaw, why do you frame this as an exhaustion of remedies issue, as opposed to PERB under the CMP, under the statute, under CMPA, has the exclusive jurisdiction to decide this case, and they did. Why is, and then where and what part of the CMPA or rules of PERB give then a right for someone who has gotten an adverse decision from PERB to have a right to a trial de novo in the Superior Court?
And sir, that's why I raised this as a matter of delay. There is case law that indicates that if the agency refuses to address the fundamental issues associated with this, and if the fundamental issues are constitutional in nature, and PERB cannot, in fact, conduct a jury trial, and he has a right to a jury trial on purely contractual issue, PERB has somehow, at least to my mind, abdicated their responsibility, their failure to act, and the 9-year delay in their responding to this matter. It made it almost impossible to avoid the catch-22 that Mr. Neal was placed into. That catch-22 being as follows. May I continue, sir? I'm sorry.
I understand your argument on catch-22. I just don't understand your argument on no decision was made. The decision, as far as the record appears to me, suggests that that a decision was made by the union, which led to a standard of contracts complaint, and that was what had happened. At that point, what was PERB supposed to do until Mr. Neal brought the challenge to PERB?
Mr. Neal could not, forgive me for going back just a touch.
Okay, please.
For 9 years, Mr. Neal could not bring the challenge to PERB. That case that he was being sued on as an employee, and the contractual language of the agreement could not be, he couldn't make it happen until after the case was completed. It was a claim for compensation that was continuing in nature.
Well,
In
it
2000
was a claim for attorney's fees.
a
correct?
claim for attorney's fees.
So
and
what you're saying is that the attorney's fees, until they were all incurred, he could not request or bring a suit to recover them from in front of PERB? Is that the argument?
That's part of it, but also PERB instructed him to wait. In fact, they said that once they believed him to have some malicious intent and in the nature of the initial problem. But they said, if you win, then you can come back to us and we will make a ruling in the matter. Well, it took 9 years, and in fact, he did win. There was no actions against him. At that point, he deserved the right to have PERB respond. If PERB had responded and had taken it under advisement, it's a very clear contractual argument. They simply say that if you're an employee, your legal fees will be paid. I have no understanding of the argument that the contract does not say that. So once they've done or failed to do what they failed to do, where else can we go? We have to make a contract claim. There was no
Wait,
choice.
are you
but a
saying that
contract.
PERB said this? I thought your argument was that in one of the memos from the Labor Committee, they implied that if you won, maybe you could come back. You seem to be saying that PERB said this. Is that what you meant?
Your Honor, no. I do understand your concern. For me to separate PERB as the agency from the directions being received by the Labor Committee, it's difficult for me to do that. And I do apologize if it appeared misleading, but as a very practical matter, he was not able to make the claim until the lawsuit was completed. He would not know differently. And I understand the distinction between compensation and legal fees, but I beg to differ. I believe they're so essentially the same, that they can be called continuing in nature until you can finally have those fees determined. That's the point that you can make your claim. And as soon as that happened, the claim was made.
The Superior Court seemed to think that if all we were looking at in terms of a response from the Labor Committee was the memo from whenever it was, 2010 or whenever, where maybe it was a
Your
little
Honor,
earlier
please
than that.
forgive me, Your
where
Honor.
there was,
I cannot hear you, Your Honor. I apologize.
oh, sorry, let me try again. Is the sound better now?
It is, ma'am. Thank you.
All right, well, let me try to be brief. The Superior Court thought that the later memo that seemed to suggest that if you were successful if Mr. Neal was successful in the Williams litigation, there might be some prospect of reimbursement, might have created a situation where there was reason to wait, but that the 2001 memo said in no uncertain terms that the Labor Committee would not provide representation or finance it. That was very clear, the court said, and that's when the cause of action accrued. What's wrong with that reasoning?
because we would not, I think it's equally as reasonable to suggest that we wait until the legal fees are completed. If this is purely a contractual issue now, no longer within the purview of PERB's standard of conduct complaint, but now becoming a constitutionally guaranteed argument that we deserve a right to have a jury trial for money damages, then we have the 3-year statute of limitations that we must respond to, notwithstanding the 9-year delay that PERB placed upon us. What else could be done? We had
Mr.
to
Bradshaw, why couldn't you have, at that point, challenged that rule, that decision by the union in front of PERB? I'm confused. The request was pay my legal fees. Under the contract, you're obligated to pay my legal fees. The union said no. I'm confused as to why you find that decision could not have been appealed or challenged at PERB and take that matter taken to PERB with your exact same argument about the contractual obligation. I don't understand why you think that was precluded at that point.
Your Honor, I wasn't there at that point. I can only look at what I see now. And I do believe that the argument I present is still available and was available when it was presented. Of course, in retrospect, I wish PERB had been more than willing to respond to our concerns. I wish that you did not have the chilling.
What did you do? Maybe I don't understand. What did your client do? What did Mr. Neal do at the point that he received the letter saying we're not going to pay for your legal fees? What was it that he filed at PERB that PERB then refused to take up?
Your Honor, I can't respond to that immediately. My mind is not, I apologize for that question. I wish I could answer that question directly now. What I can say is what I've read, there was more than significant efforts to have PERB respond and to provide the legal fees. Remember, this gentleman was in fact the chairman of the legal committee from 2000 to 2004. He was in fact being sued in his status as an employee. So he would know the political workings, the inner workings. He understands FOP.
But we would have some document from PERB. There are filings. That's an official administrative agency, and it keeps records. So if you're taking steps to overturn that decision or to have PERB review that decision, there'd be some kind of record, correct?
Yes.
And you don't have one.
Not that I'm aware of, sir, and I do apologize.
All right, that was my question.
That's
fine. Go ahead.
You understand where I'm standing. I
Yes.
do believe I have a constitutional issue. I do believe I have a right to a jury trial. I do believe that there was a contract between the employee and the agency FOP.
And why do you believe that? Why doesn't this dispute fall within PERB's exclusive jurisdiction to resolve?
The problem, we've asked for a jury trial. PERB cannot do that. And they have abdicated their responsibility. This case came to the Superior Court at one point and was remanded back to PERB for a very specific focus. And what did they do at that time? After many years, they decided, well, we'll deal with the entire issue now. That's not what they were supposed to do. That was in violation of the Superior Court's directions. And a writ of mandamus was presented to make them comply with the orders of the Superior Court. There have been many steps taken to have that. At this point, they can't be neutral. Please forgive me. I don't mean to be, well, yes, I do. I have no idea, after so many years and so many denials of access to the courts, they're still here, with their purpose being to completely deny access to the courts on this purely contractual matter. Even now, they're not neutral. They can't be neutral. If you're in the inner workings, as Mr. Neal was, Sergeant Neal was, a decorated officer was, he understood that they were not going to be neutral and he should follow the instructions. He did what he thought was best to do. It has been argued in other cases that when an agency delays, well, that can be considered. that particularly as concerns the equitable tolling that I'm concerned about. Thank you.
Mr. Bradshaw, you keep pointing out that you made a jury demand, and you did do that, but you made it in a case that was brought as a petition for review of an agency action. You did not, as the union keeps emphasizing, you never brought a breach of contract action. How do you get a jury trial in a complaint for review of an agency action? Could you have brought a contract claim at that point?
Could we have brought a claim to PERB or to the Superior Court?
No, in the Superior Court. Could you have brought a lawsuit for breach of contract?
I don't believe so. We had to do a
Why
petition
not?
for review, administrative exhaustion of administrative remedies. I do believe we had to respect the agency's process and seek a review of their decision. I believe we had to.
But you have consistently characterized your claim as a labor standards claim, a breach of, I'm looking at your brief now, the breach of the duty to maintain fair and equal treatment under the governing rules of the organization, not as a breach of contract. Isn't that a claim over which PERB had exclusive jurisdiction?
Yes, but that claim involves a contract claim for damages, for legal fees. It involved money. And they could have responded to it. I wish they had. They did not. To this day, Mr. Neal, Sergeant Neal, retired, has not had an opportunity to have that issue. It was about money anyway. It was always about money damages. He wanted compensation for representing himself for a matter that occurred while he was an employee of FOP. It's always been about money. The other matters to me, I do not intend to suggest they're red herrings, but they're not the pure issue of this. He wanted to be paid for representing himself. I think he deserves that right.
Thank you, Mr. Bradshaw. Mr. Simpson and Mr. Conti, you're both on the same side of this and you're sharing time. How do you plan to proceed?
My intention is that we share time equally, so that'd be 7.5 minutes apiece. Mr. Conti, if you want to go, I would be pleased to let you. Otherwise, I'm happy to go.
I'm happy to go first and split the time evenly.
Okay.
Okay, Mr. Conti, let's hear from you.
May it please the court, this case is not a breach of contract cause of action. It's not a common law cause of action. This is a labor relations complaint that the appellant filed with PERB, a standards of conduct complaint in which PERB has both original and exclusive jurisdiction over. To the extent that these are statutory labor relations claims, there is no right through the CMPA to a jury trial on those claims. Even if the plaintiff or if the appellant wanted to suggest that there is some sort of independent right to a jury trial on common law breach of contract claims, he would have been required to pursue that in the Superior Court. And whether or not the court would have recognized that he has an independent cause of action for breach of contract separate and distinct from the labor relations complaint is something that's never been decided because it's never been filed. PERB is entrusted by the legislature as being the unique body that is uniquely equipped to handle labor relations complaints. And if the court looks no further than the first page in the appendix, it's clear that the complaint that was filed by the appellant with PERB is a complaint under Article 17 of the bylaws of the union. The bylaws are between the union and its members. This is not a contract in the sense of a standard breach of contract claim. It is a labor relations matter that PERB is permitted to intervene on if a union member believes that the bylaws aren't being followed and that there is some sort of standards of conduct that's being violated by the union. And the
Yeah.
right.
Counsel, I do not have the appendix in front of me right now. When did Mr. Neal first file with PERB?
First filing was, Your Honor, March 15th, 2010.
So Mr. Bradshaw has talked about the delay caused by PERB up to 2010. Had PERB been involved in this?
PERB had no involvement whatsoever. The delay that I think Mr. Bradshaw is referring to is the delay in the underlying lawsuit that was brought against his client. It was pending in the Superior Court for some time. It then went up on appeal to this court and then was remanded back down. Only after that complaint was remanded back down and then ultimately disposed of on a motion to dismiss, did the appellant actually file the standards of conduct complaint with PERB. And that gets directly to the issue of why PERB found within its discretion that it was an untimely complaint. PERB has a filing requirement where if a member of a union wants to file a standards of conduct complaint and complain that the union is not appropriately carrying out its duties to the member under its bylaws, it must do so in 120 days from the date of the violation. The lawsuit that is the underlying genesis of the claim for legal fees that is being presented today was filed in April of 2001 directly against the appellant, Neal. Neal presents no evidence and presented no evidence whatsoever that he actually went to PERB at that point in time, because he didn't. Neal also presents no evidence that he actually asked for what the bylaws provide, which is not reimbursement for legal fees, but it's representation. He never asked for representation based on the record that he presented to PERB back in 2001. And if he did, the memo, which is the only evidence that we have before this court, the July 31st, 2001 vote that's reflected in the memo, the only evidence demonstrates that the union membership, the full membership, considered whether or not it wanted to fund the underlying litigation, and it decided it did not want to. And so at that point in time—
Why was that a decision the membership could make? One can read that article as saying, if you paid up your dues and you get sued because of your service as a police officer, we're going to represent you.
Well, I think if you read further in Article 17, it's not that straightforward. The language that the appellant is quoting is when you are sued civilly for your duties as a police officer. He is not being sued for carrying out his duties as a police officer. He is being sued in his capacity and the actions that he took while he was the chairman of the union. And that, we believe, is addressed further down in Article 17, where it's purely within the discretion of the Labor Committee on whether or not to provide litigation support and representation in that context. So we do believe it's a discretionary call, but nonetheless, Your Honor, even if you're correct that there was no discretion to be had, it was immediately apparent in 2001 that he was not being represented by the union, that they did not provide him with counsel, and that they were not paying his counsel. So in 2001, when that was immediately apparent, if, as Your Honor suggests, Article 17 is unambiguous, he was fully on notice that he should go to PERB, and PERB is the correct venue. And nothing prevented him from going to PERB in 2001. And it would have been perfectly appropriate and correct for him to do so, because then PERB could have resolved in 2001, when the evidence was fresh, when witnesses were available, and when memories hadn't faded, what exactly transpired, and is he owed that duty? And if he was owed that duty and that was determined by PERB at that point in time, an order would have been entered and the union would have been ordered to provide him with representation under the bylaws. That's precisely how this matter should have proceeded. but it didn't.
Are you aware of any action that's ever been brought under that provision, that Article 17, that was brought as a breach of contract action as opposed to a matter before PERB? Or are you aware of any breach of contract action based on a similar provision of any other union bylaws?
Not off the top of my head, but I think if a breach of contract action were brought purely under union bylaws and brought in Superior Court with a demand for a jury trial right, the Superior Court would correctly dismiss the matter. Because if the sole genesis of the cause of action is union bylaws, that's uniquely labor relations, which the CMPA has delegated exclusively to PERB to resolve those issues of labor relations.
You know, here's a question I actually meant to ask Mr. Bradshaw. I'll try asking you because maybe this is a term of art that I'm not familiar with. There's a section in his brief and where he says that when the union in 2010 refused his demand for reimbursement, that was a complete violation in and of itself. What I want to ask is whether there is some sort of a quote unquote complete violation doctrine in play here. Are you familiar with any such doctrine?
I am not familiar with any such doctrine. And I think what happened as this case fast forwards to 2008 is that this court remanded the case back down to Superior Court, and that is the underlying lawsuit against Mr. Neal. And at that point in time, the appellant then submitted in an October 31st, 2008 memo to the union, a request for representation under the bylaws. And that request was again denied. And at that point in time, again, if the appellant believed he was entitled to be represented, his avenue for recourse was to go to PERB and to ask PERB to enforce the bylaws and enter an order requiring the representation, which he didn't. And instead, he waited until 2010, well over 120 days from when the memo was issued, not to provide him representation, but instead to deny him representation. He waited, and he waited well beyond the time limit for filing with PERB. And then only after the conclusion of his underlying case did he actually file a complaint with PERB, not seeking money damages expressly. He was seeking in the PERB complaint representation. And that's because that's what Article 17 provides. It doesn't provide for money damages. It provides for a duty to represent. And so if there was a rightful duty to represent, our position and PERB's conclusion is that should have been advocated through the PERB process within 120 days of that becoming apparent. And it never was. And that's why the claim is time barred. And that's why the 9-year delay in bringing this claim is no fault other than the appellant's.
Mr. Conti, you've used well over your 1/2 time. Thank you for your argument. Let's hear from Mr. Simpson.
Thank you, Your Honor. May it please the court. I'm Jeffrey Simpson, I represent the Public Employee Relations Board. The only issue before the court is, and the issue that PERB addressed is whether Mr. Neal's standards of conduct complaint was timely under PERB Rule 544. It sets, as Mr. Conti alluded to, a 120-day deadline. And what this court is deciding is whether PERB's decision is reasonable under the standard of review, where this court has referred to the standard review as whether PERB's decision is rationally indefensible. The underlying matter is, the key issue is, when did the claim accrue? And what is the claim? And hearing examiner examined the facts presented. The facts are largely undisputed, that the standard of conduct complaint arose in 2001 when Mr. Neal admittedly knew that he was not being represented. And that's what the complaint is about. And that's when the 120-day deadline accrued.
Do you think he was perhaps lulled into inactivity by the letter which says he's being sued for malicious torts? And if that turns out to be true, then we can't pay for it.
So PERB held that even at that late date that the claim accrued in 2001, that letter came in 2008. And I don't think that you can fairly read that letter as, in any event, kind of as an alternative holding if there is a potential second claim, that you can read the letter and conclude that there was a promise that the union would pay. The union did not promise to pay Mr. Neal's legal fees. What the letter said, and the context of the letter, was that the lawsuit against Mr. Neal, sorry, I don't mean to be long-winded, but the context is important. The lawsuit against Mr. Neal had intentional tort components and contract components, and the contract claims were dismissed, but the Court of Appeals remanded the case based on intentional tort theories. And the union's letter said, this is not a case for your role as a officer of the union. It is in your personal capacity. And that's what it was, intentional torts that would be separate from your role. And so that's why we're not giving you representation. He knew that he wasn't being provided a lawyer at that point because the union was not providing him a lawyer. So should he have known, or should he have known that the conduct that he asserts as a breach happened at that point? Of course, he didn't have a lawyer. And that's what the claim was about. So what he comes later seeking is the damages that would be consequent to the alleged breach. And continued damages accruing is not something that lengthens the statute of limitations. So, and that has been found in any number of contexts, is that, it happens all the time where, if there's a harm that comes to you and the damages are ongoing, if you get fired from a job and, in 2010 and you're still unemployed in 2015, you can't bring a lawsuit in 2015 under the DC Human Rights Act and say, I'm still being hurt by this. Now, I'm a plaintiff's lawyer, I wish it were different, but that's just not how the courts have operated as far as the statute of limitations are concerned.
Do you think the 120-day deadline is properly conceived of as a statute of limitations?
Yes, I do. And it is a limitations period. And just to touch on this subject briefly about kind of the way the administrative process works, and we set it out fairly extensively in our brief, is that the CMPA is supposed to be a comprehensive act that covers all conceivable labor relations issues and also kind of other employment issues. PERB doesn't handle jury trials. The DC Council was entitled under the Constitution to carve out this special area of law. There's no Seventh Amendment breach or violation in having done so. The review for a PERB decision comes under DC Code section, oh my goodness, I said it so many times, 1613.17B, and Agency Rule 1, which has a standard of review for PERB decisions. There is no right to a jury trial. This court's cases in King versus Kidd, do have a limited carve out. If you think that your claim isn't properly a labor relations claim, then you can try to bring in that case was a sexual harassment claim. And so if this was a pure breach of contract claim, well, and that it's not a standards of conduct, over which PERB has the exclusive jurisdiction, then you bring in the Superior Court. And that's not what happened here. There is no complaint for breach of contract in this case at all.
Do we need to decide in this case whether the 120-day rule is jurisdictional?
I don't believe that you need to decide in the case because I don't believe that there's any winning argument on the waiver or equitable tolling issues. I don't think that there's anything here under established case law that would justify the 9-year delay in filing. And I don't believe that there's anything approaching a waiver argument where the union in their answer to the standards of conduct complaint said that the complaint is untimely and in fact included kind of substantial argument on that point. So I don't think that it is necessary. I know that, some folks would like to know if it's jurisdictional, but even if it is not jurisdictional, limitations periods have bite. And PERB's position is that it is jurisdictional. The 120-day rule was issued by PERB. PERB is interpreting its own rule, which is entitled to deference. So the decisions pursuant to Mathis and the Supreme Court don't really get to this, where the Supreme Court and Mathis, say repeatedly that it's a matter of statutory interpretation. And so in this case, it is PERB interpreting its own rule in the limits of its authority. And
I think Mr. Bradshaw first mentioned the Siam case in his reply brief because it had been only recently decided. Do you have a way of distinguishing that case from yours?
yes, the Siam case is a statutory case. So it falls under Mathis, where there is the statute was OEA's 30-day deadline. And so that is a different sort of authority for interpretation than for PERB's own rule. So the 120-day deadline came pursuant to, PERB has the authority under the CMPA to issue rules. I think it's 1605.0211 or so, and did so, and then it's interpreting its own rule, which is different than, what's the statute, the legislative intent of the council in creating the 30-day deadline for the OEA.
So you think an administrative agency, when establishing its own rules and regulations, can say, this, by golly, is a jurisdictional requirement and we really, really mean it? And that will not be affected by Supreme Court law or our own law about claims processing rules.
I believe that if the Supreme Court issued a decision about administrative agencies kind of more directly on point, then we would be in a different scenario, or if this court had done so. But right now, the controlling case law from this court is Gibson and Hoggard, which both say that the deadline is mandatory and jurisdictional.
Thank you for your argument, Mr. Did somebody have a question?
No, that's
Go
okay.
ahead.
I'll reserve on my question. Thank you, Mr. Simpson.
Thank you.
Mr. Bradshaw, we'll give you a couple of minutes in rebuttal.
You're muted, Mr. Bradshaw. There you go.
Am I here now?
Yes.
Yep.
Forgive me, guys. First, I am concerned because I would like to know if it's jurisdictional or if it's a simple claims processing matter. And the case law in Brewer and others suggest that it really is, especially when you have an agency that has participated in a good deal of delay. So that's one issue for me. I would like to know. I'm not sure exactly what Rule 544 is. Now, I also just want to make a very straightforward argument. Darn it, grievances involving money and compensation are continuous in nature, and you can bring them whenever you choose to bring them. I have to lean on that because that's where we are.
You're leaning on it, but what's your best case for that proposition? In a breach of contract case?
Sir, I generally refer to the PERB orders that have been indicated. I guess I would say the opinion number 784-52 DC regs 855, 8591 and 8593 in 2005 MPD versus FOP. I don't know that I have a case that just says that. I must admit, it makes sense to me.
Can I ask you this question? You talked about this, your right to bring a breach of contract claim under the Constitution. How do you distinguish Cooper versus ASME Local 1033, in which there was an argument raised that Cooper did not have to go, it could defeat the exclusive jurisdiction of the PERB by casting his complaint as a common law breach of contract, as opposed to a breach of the duty of fair representation under the contract. The court said, no, you can't get around PERB's exclusive jurisdiction by calling it a breach of contract case and therefore invoking this seventh, the right to a jury trial. Is that a case that you can distinguish for us?
Yes, my client was experiencing a significant amount of delay in this matter. The agency denied at every stage his request for compensation. Well, I'll say legal representation. I don't think there's really a distinction between legal representation and compensation in this issue.
But how does that distinguish? How does that distinguish this case from Cooper? Cooper's talking about the exclusive jurisdiction of PERB to hear these cases. It's not talking about delay and whether delay makes a difference. You're arguing to us that because PERB, you got a case where you were denied representation in 2001, you filed in 2008 with PERB, or 2000, I think it was 2008. I may be wrong about that.
2010.
2010, right. So I'm again really having difficulty understanding how PERB's delay caused, even if it did, why Cooper isn't dispositive of your claim that you have the right to bring an independent lawsuit, even though it involves a union contract, in the Superior Court.
The phrase that you use, even if it did, I can't pass up. If it did, then Mr. Neal is being denied his access to courts at every turn. If it did, then I would argue that he still has a right to bring a purely contractual claim at any time. I don't believe the law would.
So you don't think Cooper precludes it?
No.
You think Cooper just says that, but it doesn't preclude it?
Sir, I wouldn't presume to put it in those words at all. I'm advocating for the position that we have, and the position I have before you today is we have a right to a jury trial. I'd like to get there.
Okay.
Thank you, Mr. Bradshaw, Mr. Conti, Mr. Simpson, thank you. The case will be submitted and the court will stand adjourned.
Thank you very much. Can you please check me out? I have no idea what I'm doing.
This court is now adjourned.
Did a good job, Mr. Bradshaw.
Thank you.
Okay, councils, if you can exit out.